On Thursday, the Supreme Court released a handful of new decisions, one of them highly controversial, but somehow still unanimously agreed upon, and at least somewhat praised by activists on both sides of the issue. In Fulton versus City of Philadelphia, the city had severed its contract with Catholic Social Services, an agency that places children in need of foster care with foster parents. But per the organization's religious beliefs, the agency would not place those kids with gay couples. Also, according to their beliefs, the agency would not certify unmarried straight couples either. The issue in this case is theoretical rather than practical. In fact, no same-sex couple has even sought foster parent certification through this Catholic agency. But after an article in the local paper described the policy in 2018, the city severed the contract. In doing so, the city claimed the Catholic agency had violated the city's non-discrimination policy. In its lawsuit and through the court system, Catholic Social Services has argued that the city violated its First Amendment right to the free exercise of religion. So what we have in this case is a classic battle between the rights of religious exercise and association and conscience, etc., versus the right not to be discriminated against, or at least government's right to create and enforce non-discrimination policy. This is a recurring fight that we see constantly, and one on which there's passionate and entrenched opposition. So how exactly did we get a unanimous ruling in this case? How is Pinko Sonia teaming up with Handmaid Amy? And why are activists on both sides at least partially praising the decision? The law firm representing Catholic Social Services celebrated the protection of faith and religious freedom. The Philadelphia Archbishop called the decision a crystal clear affirmation of First Amendment rights. But the other side saw benefits too. The president of Americans United for Separation of Church and State says there's a win for her in that religious extremists did not get the sweeping free pass to discriminate however they want. The president of the Human Rights Campaign says the decision is at least a partial victory in that it doesn't negate the fact that every qualified family is valid and worthy. So how is that possible? How are justices and activists with almost no philosophical agreement on this issue, or any other for that matter, both celebrating this case as a win, or at least partially praising it? Well, it's because this decision was written by the master of meaningless agreement, John Roberts. This case was originally seen as a direct challenge to a prior case called Employment Division versus Smith, in which the state of Oregon punished a Native American employee who had used peyote as part of a religious ritual in violation of state law. In a controversial and often criticized Scalia decision, the court said that as long as the law in question is a neutral law of general applicability, as in the law doesn't single out or target any particular religion uniquely, it's not a violation of the Free Exercise Clause. And that decision is a highly debatable one. To Scalia's point, if you can claim religious exemption from any law, I have a religious exemption from seatbelt laws, or I have a religious exemption from zoning laws, sign me up for a religious exemption from federal machine gun regulations personally. But if you can do that, wouldn't all law be rendered effectively meaningless? Just religiously object to whatever laws you don't like. But to the other side, if any law that's generally applicable to all religions is constitutionally square, could a state just blanket ban all religious worship generally, as long as it doesn't single out any one particular faith in doing so? The limiting principles on both sides of this case are extremely difficult to identify. And John Roberts had an opportunity to carve out those principles, to give constitutional definition to this conflict. But of course, he didn't do that, because the hallmark of the Roberts Court is not principle. The hallmark of the Roberts Court is agreement on meaninglessness, and that's exactly what John Roberts crafted with this decision. Instead of applying or scrutinizing the decision of that prior Smith case, Roberts simply sidestepped it, saying Smith doesn't actually apply here because Philadelphia's non-discrimination policies, he says, are not neutral and generally applicable. So that Smith case is irrelevant, and this case will be decided only on the terms of this particular set of facts and this particular contract in Philadelphia. Now, I've tried to read Roberts' argument as charitably as possible, but frankly, I just can't understand it. I do consider myself on the side of the Catholic agency in this case, but it seems to me inarguable that the city of Philadelphia's policy is neutral and generally applicable. They have the same exact standard for the Catholic agency as they do for any secular one. The proper analysis is to decide if the Smith standard is correct, or if Smith should be overruled. But Roberts doesn't do that. And the only reason I can see for that decision, again, because the stated reason makes no sense, is a cowardly unwillingness to rock the boat, even when the boat is wrong. And the problems with making decisions on specific technicalities rather than broad constitutional principles are, one, you write decisions that have no applicability beyond the case at hand, so they're mostly useless. And two, since you didn't decide on the substance of the issue, you invite the exact same issue to be challenged through the courts again, which is exactly what Gorsuch rips Roberts for in his concurring opinion. Gorsuch writes, quote, "Perhaps our colleagues believe today's circuitous path will at least steer the court around controversial subject matter and avoid picking a side. But refusing to give the Catholic agency the benefit of what we know to be the correct interpretation of the Constitution is picking a side. And so these cases will keep coming until the court musters the fortitude to supply an answer." And that's not theoretical. That's not some warning of a faraway future development. That's what we're watching right now. We don't have to wonder when this case will be brought again. This already is a case that was brought again. This case is factually similar to a case the court already decided in 2018, the famous case of Masterpiece Cakeshop v. Colorado, the case where the state tried to force baker Jack Phillips to bake a gay wedding cake. In both cases, the state attempted to force the provision of services against religious conscience. In fact, the Catholic agency in this case appealed to the reasoning the court used in the baker's favor last time around. So why wasn't this controversy already settled 3 years ago? Because back then, the Supreme Court pulled the exact same move. A refusal to analyze the fundamental rights at stake, opting instead to focus on some technicality to weasel out of the issue. Now, in fairness to Roberts, that was a Kennedy decision, but it is one that Roberts joined, and it focused on how the Colorado Civil Rights Commission showed particular hostility to baker Jack Phillips' religious beliefs. Because the state of Colorado was too dismissive and rude about Jack Phillips' faith, Jack Phillips won that case, which says nothing useful at all. The logical extent of that reasoning is that the state could force this guy to bake the gay wedding cake as long as the state is nicer and more polite while doing it, which of course ignores the legal principles at stake and offers nothing to the next guy to whom this happens, even if that next guy is Jack Phillips again. See, it's not just that these decisions on technicalities rather than substance invite the same issue to repeat. They don't even protect the same guy from the same injustice. So now Jack Phillips is back in court, or has been, repeating the exact same fight. But instead of a gay couple trying to force him to bake a wedding cake, this time it's a transgender activist trying to force him to bake a cake that's pink on the inside and blue on the outside to symbolize transgenderism. The same day the Supreme Court agreed to hear the baker's prior case, this trans activist lawyer called his cake shop to request this transgender cake, which Phillips refused. A few days later, an associated number called Phillips to ask for a cake depicting Satan smoking marijuana, which Phillips, again, refused. And then a year later, when the original Supreme Court decision was issued, an email suspected to be from this trans activist lawyer requested a cake depicting Satan licking a large sex toy, and it was supposed to be functional, which Phillips, again, refused. This trans activist law practice website takes an implied shot at Phillips, saying, quote, "We take great pride in taking on employers who discriminate against LGBT people and serving them their just desserts." And this new case, same as the old case, was decided this week in Denver District Court. And the court decided against the baker Jack Phillips because he had originally agreed to bake this blue and pink cake before its transgender meaning was explained to him. He only refused after learning of the intended transgender messaging. Right, because he disagreed with the messaging and didn't want to be compelled to say it, not because he refuses to serve certain people. That's been his argument the entire time. That's not a gotcha. That's proving his point. But the court didn't accept that argument. The court says a reasonable observer would understand that the message is the trans activists, not Jack Phillips. Well, sure, just like when I see a billboard, I assume that the message is the advertisers, not the crew of workers who placed it. But the fundamental question remains, does the state have the right to force those workers to perform that labor? Or can they opt out of it for any reason they like, including that they disagree with the message. Ironically, Jack Phillips is pledging to appeal this latest case as well, so perhaps the Supreme Court will soon see him again and prove Gorsuch's prediction true, not just in general, but for the exact same guy with the exact same issue. Until the courts address these questions, they leave us to this harassment war where we pretend that a person trying to coerce someone into depicting satanic sex acts through cake is somehow a helpless victim. But hey, at least we have consensus on the legal technicalities of each particular episode of this nonsense individually. Consensus is not a value. Agreement is not a principle. Getting along is not a moral. And more importantly, in this context, none of these are constitutional clauses. About what is the key question? Consensus about what? Agreement about what? Getting along about what? Because if there's no fundamental substance to what we agree about, it's all just imagery. It's all just pretend. And we'll keep warring without respect to each other's rights. May the biggest satanic sex toy win. Thanks as always for listening and for supporting this channel. Always appreciate that thoughtful discussion down below, and especially over on Minds. That is at ML Christiansen. You're always welcome to coming out and chat in my live streams. Those are linked down in the description. Looking forward to it. Goodbye.